parties to go to the conservatorship court. Some factual background. Mandi was born in 1982. Because of her birth injuries, her parents brought a medical malpractice lawsuit. In 1988, Judge Robert McRae of the Federal Court for the Western District of Tennessee approved by court order a settlement. That settlement included a structured settlement agreement whereby the med-mal defendants funded an investment in an annuity that would pay Mandi Gregory monthly payments for her lifetime. The record shows that settlement agreement provided that those payments, quote, may not be varied by any party. Years pass, Mandi Gregory becomes an adult. After she's an adult, she no longer can rely on a guardian, because guardians are for minors. Her parents were her guardians. She has to have a conservator. So at that time, the family lived in Madison County. The Madison County Court appointed both her parents as her conservators. Her father became a convicted felon. By statute, he was immediately unable to be a conservator anymore, disabled from being a conservator. Mandi's mother was her sole conservator. Peachtree, a defendant in this case, an appellee in this case, represented before you, negotiated a deal with Mandi's mother. We will give you 6 figures. We will give you a lump sum of $142,000. Just sign over 20 years of these payments coming to you under this annuity. An annuity is an investment. An investment is something that generates income. That annuity was an investment. Mandi's mother was talked into agreeing to accept this 6-figure lump sum in exchange for just transferring away these monthly payments. Now, the conservatorship law says that if a conservatorship court doesn't seize property over $25,000, they can waive a property management plan. When the conservatorship was started, Mandi had no assets. She had the rights to this income stream from this annuity, but this income stream was not sufficient to generate capital that would ever be over $25,000. So there was no property management plan in place. Peachtree went to a court in Anderson County, Tennessee, over 300 miles from where Mandi lived, where the conservatorship was, and they, under the Structured Settlement Act, they got a chancellor there to approve this change of the investment in the annuity to a lump sum.
Was the conservator notified?
The conservator was Mandi's mother, but the Peachtree petition only ever identified her as guardian. Guardian is for a minor, and on the face of the pleadings and the record in the Anderson County cause, it's clear that the settlement company, Peachtree, never disclosed to the Anderson County Chancellor that a conservatorship existed. They only used the term guardian. Although it's clear at the time in 2008, Mandi was 24. She was an adult. She had to have a conservator.
The conservatorship was in Madison County?
Madison County. And Tennessee law says that, and in fact, Judge McGee in 2021 wrote in the TAP opinion, trial courts should not exercise jurisdiction over the person or property of a non-resident person with a disability. Conservatorship courts, once they assume jurisdiction over someone, have jurisdiction over that person and their property. And Judge Clement, writing in AmSouth Bank against Cunningham in 2006, recognized that the authority, rights, and responsibility of a conservator are not independent of the court. If you're going to make a change in investment for someone in a conservatorship, go to the court overseeing the conservatorship. Venue is jurisdictional in conservatorships. Now, the defendants will argue that, well, the Structured Settlement Act allows us to go anywhere. Well, that's true. But the Structured Settlement Act does not, is more general. The conservatorship statute is very specific and applied to Mandi and the investment that was made for her benefit by court order from a federal court judge. But these defendants went to Anderson County, didn't disclose the conservatorship, no guardian ad litem was appointed. It was basically rubber stamped, went through without opposition. The other defendants in this case, and we don't have time to get into the structure, but basically the Med-Mal defendants assigned their obligation, all their obligation to pay Mandi to Federal Home Life Insurance Company, who's a defendant here, FHLIC. FHLIC bought the annuity, and the annuity made payments to Mandi. Peachtree came in and took 20 years of payments. If you add up the payments, they total over $1 million. They gave Mandi's mother $142,000 and required the mom to buy life insurance on Mandi so they wouldn't lose money if she died. Mandi is now, I believe, 44. Every month that goes by is another month that she is losing those annuity payments. What happened is this trial judge, on a motion to dismiss, looked at the statute that says a conservator can sell an asset if there's no property management plan in place. A conservator can sell an asset without court approval. Well, sure, if Mandi's mother had had a car and wanted to sell the car, she didn't have a property management plan in place, she could have sold that car. But the statute that governs what happened here is the statute that requires conservators to get court approval before the change in the nature of an asset that is an investment.
Did the trial court rule on any of that?
The trial court...
I know you're making an argument about whether this is an investment or a sale or whatever.
That's the whole basis for the trial court's ruling. Initially, the trial court said, if you're in a conservatorship, go to the conservatorship court for things like this. But then Peachtree said, oh, no, please reconsider. The statute that allows a sale of an asset doesn't require court approval of a conservatorship court. And Judge Bradbury, on a motion to dismiss, looked at this as a sale. Although in a motion to dismiss, every fact needs to be looked at in the light most favorable to the opponent of the motion. If you're looking at the facts most favorable to Mandi, this isn't just a sale, and that statute is the sole basis for Judge Bradbury throwing this whole case out. He said it was just a sale. They didn't have to go to the conservatorship court. The error is on a motion to dismiss, a trial judge must look at the facts and draw all the inferences in favor of Mandi. And the inference should have been, this was a change in the investment, change in the annuity. So they had to go to a conservatorship court. So the bottom line is, the Chancery Court of Anderson County had no subject matter jurisdiction because that jurisdiction was with the conservatorship court. Having no subject matter jurisdiction, which is obvious from the face of the record, which is in the record in this case, that order is void, and we should be able to proceed with this case as the Chancery Court that now has Mandi's conservatorship has appointed Melissa Stewart to pursue this in court as to why these defendants were allowed to take assets from a disabled person and completely avoid any involvement by the court overseeing her conservatorship. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Cam Hillier of the Memphis Bar on behalf of Appley Settlement Funding, LLC. They go by Peachtree. As an initial matter, I will be Mr. Bragg as counsel for the other Appleys, and I know we have to divide it up, so we will be splitting the babies 7 minutes, 30 seconds each, if we can hold it to that.
We can't do that. We can go full minutes, but we can't do seconds.
How about 7?
7 and 8.
I want.
You can have 8, sir. I'll take 7.
Thank you. 8 minutes, please. Your Honors, you just heard the whole history that appellant has laid out, starting back with the personal background and the history all the way up through 2001 to 2006 to 2024, and the 2023 order by Judge Bradbury. Where I'll focus for the limited time, and I know your honors have read our briefs, is in 65 pages of the appellant's brief, 18 pages in a reply brief, and 10 minutes at oral argument, there has been no discussion of the 2001 order. And the reason for that is, if your honors would look at it, it is a very inconvenient fact for the appellant because of what it contains. And it is exactly what Judge Bradbury looked at when he made his decision. And despite it being an inconvenient fact for the appellant, it doesn't excuse that it goes to the core matter, which is before this court, is this isn't a retrial of a 2006 Structured Settlement Protection Act best interest hearings in which a judge made findings of fact, of jurisdiction, venue, best interest. That order is a final order from over 19 years ago, 18 years ago. What I would direct you to is the order appointing the co-conservators. And again, this is Galen Gregory and her husband at the time, and their now of-age daughter, Mandi Gregory. In that order, this was done in the Madison County Probate Court, and it was done by Judge Little. I'm not familiar with Judge Little, but it was done in 2001. It says specifically in there, all the requirements for posting a bond and filing annual accounting are waived. This is after it appoints both. This is mother and father for their daughter. Requirement of filing a property management plan is hereby waived. That's all we've heard so far. Goes in detail in paragraph 4. All the rights of respondent relating to the management of her property and all rights to make personal and medical decisions are hereby removed and transferred to the co-conservators. Such rights removed and transferred include, without limitation, respondent's right to dispose of property, execute instruments, contracts, make purchases, enter into contractual relationships, hold a valid Tennessee driver's license, and give or refuse consent for medical and mental examinations. Further, if that wasn't enough, the co-conservators are relieved of posting any bond, filing any annual accounting, and filing a property management plan again, all initialed CRL, CRL, CRL for Judge Little. If that wasn't enough, to go on further, the co-conservators are authorized, this is a pre-authorization, to deposit and invest any funds available for the respondent and to make the necessary expenditures and withdrawals for the care of the respondent, including encroachment on principal, which I would add is we're all familiar in any type of receivership action, a trust with a trustee. Encroachment on the principal is one of the most significant things. So I would say that this is a 2001, and I don't want to be coy about it, but this is what would be akin to this is a kitchen sink order. This is Miss Gregory and Mr. Gregory went in with counsel to Judge Little. There was a guardian ad litem for Mandi, and they asked for this order. And Judge Little gave them this order and basically set them no holds barred. You're allowed to, obviously, you can't allow them to do things that would be mistreat the child or steal from the child. But everything else, you are authorized and all the requirements are waived for you to go forward and take care of your adult child. That's clear. That's a plain reading. We don't want to talk about that because what we don't want to talk about is that Galen Gregory came to Peachtree and wanted to sell the payments of Mandi Gregory, for which she was the court-appointed conservator at that time. There's no one else. I'm not going to sit here and argue whether or not a pleading said guardian or conservator or whatever. It was clear that I'm doing this on behalf of someone and I'm signing the contracts on behalf of a disabled adult. And the reason that it went to the reason it went to Anderson County, frankly, it's irrelevant. There was no venue provision. Counsel for Peachtree at the time was in Oak Ridge, which is in Anderson County. He brought it If you can bring it anywhere, maybe there's more, I don't know. But there is no venue,
Does
so
the statute say that you can bring it anywhere, or does it just say that circuit court would have jurisdiction in connection with applications to sell the structure?
it says circuit court has non-exclusive jurisdiction.
But it doesn't say that you can file it in any county, does it?
It has no venue, it's silent as to venue until 2016.
And now it says what?
It says you got to file it where the person resides. That was 2016, put in by the legislature.
Right. Cleared up any ambiguity about where you could file those by this amendment in 2016.
There's no dispute about what the statute said
But
then
again, the
and now.
earlier statute doesn't say that you can file it at any circuit court, does it?
No, it does not, and it also does not say you may not file it in any place.
Let me ask you, Judge Bradbury, initially when he heard this motion, he denied it. Later, he granted it, and then he cites the 34-1-116, which talks about sale of property. And looking at that statute, looking at any notes under it, looking at any cases that interpret that statute, that you find a single case that says that property refers to annuity payments.
I'm not sure I understand the question, Your Honor.
Does the statute define property?
Which statute?
34-1-116.
Which would be the sale?
Sale of property.
No.
Does it define property?
I do not know that. I can certainly pull the statute and look at the definitions. I don't have
And then
150.
in connection with your research concerning 34-1-116, did you find a single case that applied that statute to an assignment of an annuity?
No, Your Honor, we did not brief that. I have never done that research.
Okay. But I mean, that's the statute that the trial court relied on and changing its mind, right?
I believe the trial court made it clear this is a sale, that basically the 2006 Chancery Court in Anderson County, it is a sale. It is a sale or transfer.
That's what the trial court said. But is it a sale, or is it a change in the investment of the annuity?
Okay, and I believe if that is where we're going, then the question I would answer that back is, I absolutely believe it's a sale. Judge Bradbury believes it was a sale. The word sale is in the 2006
But it
order.
says sale of property. It doesn't say an assignment of an annuity, because that's what we really have here. We have an assignment of an annuity. We don't have a sale of property, do we?
Well, Your Honor, I would answer that. I'd say I assigned my car to you. I sold my car to you. I think when you said we've all seen sale and assignment agreements. It's a transfer. It's a transfer of ownership rights in exchange for money, and I believe that's what we are to sale. And I'll address that further on the change of annuity. This came up after the fact, and despite how many times the appellant refuses to use the word sale and say change of annuity, change of investment, it doesn't make it a change of investment. The annuity has not changed at all. They were merely a beneficial payee. She's not the owner of the annuity. She's not the issuer of the annuity, just like you're getting payments from a trust. You just receive payments and the trust can change payments. You're not the funder and you're not the trustee. She sold her rights, and that's what she sold to Peachtree. And I would just end, and I'm happy to answer any further questions, that I think what the court needs to look at is even if it was a change of investment, and this, I know my time is up, even if it was a change of investment, I urge the court to look at number 6 of the order that has the word invest in it. Deposit and invest any funds. If you're gonna say investment and you're gonna say sale is up there, investment's down there. That court in 2001 authorized Ms. Gregory to go anywhere on behalf of her daughter, and she chose to do that.
Little's order in 2001 could trump Judge McCrae's order in regard to that settlement, which says that you can't do any of that.
Can Judge Little, I don't believe Judge Little approved the sale. Chancellor Landtrip in Chancery Court in Anderson County approved the sale.
But your argument is that Judge Little, in her order in 2001, authorized an encroachment on the principal, authorized the sale. And so my question was, does that trump the district court's decision concerning this settlement, which included provisions that there was not to be any assignment, there was not to be a lump sum payment of any part of that annuity, which occurred here?
Yes, Your Honor, and I'll let, and my time is up, and I'll let other counsel address that. That goes to, my client wasn't a party to that settlement, and that settlement was addressed by Chancellor Landtrip when he approves that, just like, as all courts look at that when they have to approve this by statute. Thank you.
Your Honors, and may it please the Court, Brian Burak, Pro Hoc Vice from the Bar of Pennsylvania. Thank you for the courtesy of being here. I represent the other two appellees, the insurers, so to speak, Federal Home Life Insurance Company and Union Fidelity Life Insurance Company. Federal Home is the entity that took the qualified assignment. And so I think the first thing to be very clear about is, although we're sitting at the same table, of course, with my friend, we're sitting on different parts of this equation, because my clients were not present at the structured settlement proceeding. My clients, under the Act, are entitled to notice as an interested party and have an option, an opportunity to appear and object, but no obligation to do so. And importantly, here didn't. So it's just an important factual aspect of this case that there's no dispute that my clients weren't there, didn't say or do anything at that proceeding. And that's important because my clients are also not a party to the original settlement agreement where Judge McCrae approved certain language about what may and may not happen. My clients only took the assignment to the extent that they did. And under the qualified assignment,
Were you subject to that?
only to the extent of the accepted assignment. So no, in the sense that we're not subject to all of the terms of that original settlement agreement. So the original settlement agreement does have more general language about the non-assignment, but in the qualified assignment that Federal Home took on as assignee and taking on the structured settlement payment rights as now obligor, what they took on is they will not accelerate, defer, increase, or decrease. But that's not what happened here. I don't think there's a meaningful dispute that by changing the identity of who gets the money, we're not saying you get it more quickly or less quickly or at this time or not at that time. That's what those four things are. There is other language in the qualified assignment that deals with the anti-assignment provisions, but the obligation not to do those things didn't fall onto Federal Home. It fell onto the Gregorys. And so at the transfer petition, my clients could have theoretically appeared if they had wanted to, and could have made an objection if it had wanted to under the anti-assignment language, but didn't. And there's no basis for a finding of duty either in the contract, because we didn't assume a duty not to do those things, and nor is there a duty under the Structured Settlement Protection Act, which doesn't provide any duty to come, qualifies us as an interested party, and gives us an opportunity, and moreover has another provision that removes us from liability in the aftermath of the transfer. So ultimately, the conservator statutes, of course, protect disabled persons, and here we submit the court below got it right in the sense that the transfer petition was taken to a court of competent jurisdiction. It was a court-approved sale, and my clients were entitled to rely upon what was a facially valid order. So regardless of how...
Let me pose a question for you.
Of course.
About the Anderson County Court. In Tennessee, we have a doctrine called prior suit pending. You have a conservatorship, which I assume is still pending in Madison County, unless it's been transferred somewhere else. The whole purpose of the conservatorship is to protect the ward. Why would any sale of assets that belong, sale, change of investments, not be required to return to Madison County under the prior suit pending doctrine?
I don't have a good answer to that, although it's a good question.
Thank you. Appreciate that.
Certainly there is a logic to going back to the original court. And certainly, under the statute, for sure, there are the general rules that it is supposed to go back to the conservator court, and we can all understand why that would be. But we do think that the statute, I think my better response than I don't know, Your Honor, is that the statutory exception that's written in, I think respectfully would supersede that general doctrine, because you've got an actual statute that's saying you must go back to the conservatorship court except where certain exceptions are met. And here, the waiver of the property management plan, I think would trump that general doctrine, despite what I said just a moment ago in having a specific statutory exception, which if met, would not have required it to go back there. On the practical question of why they didn't go back there, of course I don't know, including because, importantly, our clients weren't a part of that. So regardless of how this court resolves the question of the subject matter jurisdiction of the transfer petition court to issue it, there are a number of other reasons this court can affirm as to my clients, including the one I started with, which is that there's just no duty. And I think I've seen my friend on the other side to concede that there was no duty to appear at the transfer petition proceeding. And as a result, that is a separate independent basis to affirm the motion to dismiss as to our clients.
I notice you call it a transfer proceeding, and you don't say the application for sale of the annuity. Is there a reason for that?
No, Your Honor. We believe it's a sale. We stand by that it is a sale within the meaning of the conservatorship statutes. It is, in fact, an assignment. It is, in fact, a sale of structured settlement rights, the right that flows, of course, from the underlying settlement.
I'll ask you what I asked earlier. In looking at 34-1-116, sale of property, did you find any case that involved a transfer of rights or an assignment of an annuity?
Not that I'm aware of.
Statute.
I understand the question. Not that I'm aware of.
And why wouldn't 34-1-115 apply to this? Because you're changing the nature of the annuity. And in this case, keep in mind, it reduced it to a lump sum payment and then took $70,000 from that payment to purchase a life insurance policy that protected Peachtree, not the ward, protected Peachtree. That is a change in the nature of that annuity, isn't it?
Respectfully, we would disagree with that. You're right that I don't have a case that I can show you. I think the nature of this is it is a property right stemming from a lawsuit, like any other money judgment that you get is treated like property. So respectfully, I just think the plain meaning of it is that it's not, regardless of how it ultimately was being used. You could presumably have that same situation with an ordinary monetary judgment. However, it happens to get used later. I see I'm out of my time. I stand on my papers and will obviously answer any questions you may have, but otherwise, thank you, Your Honors.
Judge Stafford, to answer your question, the conservatorship has been transferred from Madison County to Hardin County. It's the Hardin County Chancery Court that appointed Melissa Stewart to pursue this litigation, specifically to pursue litigation about the money that changed hands resulting from that
The
06 order.
conservatorship is still open.
The conservatorship is absolutely still open.
I have a question about the mother, Miss Gregory. Has any court determined that she was acting in the best interest or not in the best interest of the ward at the time?
That issue is before the conservatorship court. There is a motion to replace her as conservator for reasons that I do not know. That motion has not been ruled on, but she's absolutely, a motion to remove her has been filed, and the court is aware of her role in this lawsuit and knew that the reason Ms. Stewart was appointed was Ms. Gregory had to be sued in this because she breached her fiduciary duty. But very quickly, Judge Little's order allowing the Gregorys to handle things was entered when the only asset Mandi Gregory had was the income stream that came to her from an annuity that Judge McRae had said, you're going to get these monthly payments, and the annuity that generates these payments and the payments can never be varied. In the record at page 28 is the settlement agreement that says the parties acknowledge that the periodic payments will be fixed and determinable and may not be varied by any party. So Judge Little, in her court, she had people who had no control over this income stream. So her allowing them to invest money, yeah, sure, if a monthly payment came in and they didn't use it all on Mandy's care for a given month, sure, they could take that monthly payment and put it in the bank or choose to buy a better wheelchair for Mandy. But when Judge Little entered her order, Mandi Gregory's conservators were they were receiving payments from an annuity that they could never vary. And the obligation not to vary is in the settlement agreement. FHLIC is absolutely a party to that settlement agreement because they signed the qualified assignment of the annuity to it, and it stepped into the med-mal defendant's shoes to make the payments as required by the settlement agreement. So FHLIC absolutely had an obligation to recognize that those payments could not be varied, and they should have appeared in Anderson County, and they should have brought the settlement agreement to the Anderson County Court's attention. They did not, and that's a part of the reason the Anderson County Chancellor had no idea what he was dealing with. If you look at this record, the record in the Anderson County case, Peachtree said, oh, we can't find the original documents that created this annuity. We've got them in this court right here today. We don't know why they couldn't find them back in 2006. Anyway, Judge Little's order allowing the parents to handle Mandy's money, whatever might be left over after they expended payments from the things, that doesn't override the statute that requires conservators to come to a conservatorship court if they want to make a change in an investment. And a sale is involved in any change in an investment. If a conservator owns only Boeing stock and they decide they want to get out of that and go into a diversified mutual fund, they're going to change that investment. They've got to go to the court to get approval. Somebody might argue, oh, it's a sale, it's a sale. They're selling Boeing stock, that's a sale. Well, it is a sale, but it's in the context, as Your Honor pointed out, of a change in the nature of an investment. So the defendants here were required to go to the conservatorship court. They did not. They absolutely varied and changed this investment. Contrary to Judge McRae's court-approved settlement, they changed the payee. Is there anything more fundamental about an investment than who receives the monthly payments? And one thing we've cited, we did find some cases that are cited in our brief. Somebody wanted to cash in a life insurance policy for a conservatorship, and the court recognized that was a change in the nature of an investment. That was the closest thing we could find to what's happened here. The defendants talked a conservator into accepting what was a lot of money, 6 figures, in exchange for taking away 20 years of payments worth over $1 million that were designed by a federal court to give this disabled person a comfortable life and a shot at getting a good wheelchair and maybe some good therapy throughout her life. We ask you to reverse the trial court's grant of a motion to dismiss. The trial court looked at the record and interpreted the facts in the light most favorable to the movements. And that's not how motions to dismiss should be heard. We ask you to reverse that ruling, send us back to the trial court to proceed. Because if you affirm this, the entire case goes away. But if you reverse it, then we can proceed and present our issues to the trial court below. And thank you so much for hearing us.
Thank you, counsel. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We'll stand at recess to the call of the docket this afternoon.
All rise.